All right, moving right along here to the second part of the Torts video series. This is the most important part. Negligence is because it is about, I think, 50% of, give or take, of all the torts questions on the exam compared to parts 1, 3, and 4, which are, I guess, about 17% each. This is the main focus of your studies should be on negligence as a result. So, let's start with a bit of a refresher. The four elements of a tort. This should bring you back to day one of law school. I'm not sure if that's a day you want to relive or not, but nonetheless, here we go. There are four elements if you want to be successful in advancing a tort, and they are 1, duty, 2, breach of duty, 3, causation, and 4, damages. What we're looking at here is part 1 of those elements, the duty question. So the plaintiff must be owed a duty by defendant in order for there to be a tort. What is a duty? I'm obviously thinking of Family Guy and all the jokes you could think of when I said what is a duty, but what we're talking about here is a legal duty, D-U-T-Y. And that is when you have to do something, and if you don't do it, you can be legally responsible. An example, in contracts, if you enter a contract, you make a promise to do something, you have a duty to fulfill that promise. If you don't, you can go to court for breach of contract. In torts, there is also a duty, and that is a duty to take due precautions to minimize the harm to foreseeable victims. What does that mean? It basically means you need to be a cautious and careful person. And that caution and that care has to take into account people that could potentially be harmed by your actions, namely foreseeable victims. In other words, the defendant can only be asked to be cautious to things that he could foresee. The example that comes to mind is the Palsgraf case. Again, we're going way back to the first days of law school, probably. And that, if I need to remind you, is the famous case where two bozos that work for a railroad company push some guy on up onto a moving train, and he's an even bigger bozo because he has fireworks or something like that in his suitcase, and somehow, I have no idea how this would happen unless they were lit, but they explode, and that happened because these guys pushed him onto the train. He dropped his suitcase, it fell, explodes, people run, things knock over, and lo and behold, poor Mrs. Palsgraf is standing down on the platform a ways away, but she gets, they call them scales. I don't know exactly what hit her, but something hits her. It's a series of steps between the pushing of this guy onto the train and the injury to Miss Palsgraf. It's usually taught in terms of proximate cause, but a interesting way in looking at that case is through the eyes of duty, and understanding this will help you think of duty when you are reading a MBE question or a fact pattern or anything on the bar exam. So the idea here is, the question here is whether those workers from the railroad company owed a duty to Miss Palsgraf. Well, I said that you owe a duty to everyone to be safe, to take precautions, fine. But in this instance, they were pushing somebody onto a train. In doing that, Miss Palsgraf, all the way down the track, down the platform, was not a foreseeable victim. When they thought to themselves, should we push this guy onto the train? Okay, well, there's obviously some danger we might injure this guy. I don't know. But they were not thinking of Miss Palsgraf, and nor should they have been. She was not foreseeable. There was no way for them to think that pushing someone onto a train could have hurt her. They had no idea there was fireworks in the being held by the passenger. So, since there was no duty to Miss Palsgraf in what they were doing, there was no duty that could have been breached. And since there was no duty or breach of duty, there was no tort. And without a tort, Miss Palsgraf couldn't get damages from the railroad company. So to think of that, it's not simply that you have to just be a cautious person. It's that the measures of caution that you take need to take into account some foreseeable victim. So you look at the plaintiff. Was he or she a foreseeable victim when the defendant was taking precautions or not taking precautions? So that is the only extent of duty, it is to foreseeable victims. That, of course, is not always the easiest question to answer, and I don't think this should come up that much, but if it does, it's this idea of whether or not, when the defendant was deciding to be careful or not, could they have thought of the plaintiff? Could the plaintiff have been somebody in mind when they were deciding to be careful? Another aspect of the duty question here is the idea of a failure to act. This happens, this is rare. I don't know how often or if it would appear on a question that easily. But, for instance, if a defendant is driving a car, he has set that car in motion, and if there's a plaintiff ahead of him, he has a duty to step on the gas. Or, excuse me, he better not. He has a duty to step on the brake. That way he doesn't hit the plaintiff. So it's a failure to act if he doesn't step on the brake. That is the basis of the tort. So the duty can be breached by simply failing to act, or the duty can be breached by an act, by if he turned his car into the direction of the plaintiff, that would be breaching a duty by an action. Another aspect of failure to act is if there's some special relationship or status. Common carrier or innkeeper has a duty to protect people under their care. This is a bit outdated. This goes back to, I don't even know when, ancient, not that ancient, but I'm thinking of Abraham Lincoln going to some inn when he's traveling, and that innkeeper has a duty to protect the guests. That I don't think if I go to the Hilton, the manager has some. They do. I should say they do, but it's just different today. But nonetheless, common carriers or innkeepers have this special duty that to protect the people under their care. If there's some storm or a hurricane, you're not just on your own. It's the hotel that has to protect you. So if they fail to act, if there's a hurricane and I'm in the Bahamas staying at Club Med, and the hotel doesn't do anything to try to protect me, well, then they're liable for failing to act when they should have. Another aspect of duty here is if somebody is in harm's way. So there is a duty to act if the defendant is the one who caused the plaintiff to be put in harm's way. Normally, there's no general duty to rescue somebody. If I am taking a walk and I look and I see somebody's hanging off a branch on a cliff and they're screaming for me to help them, I don't have to help them legally. It would be terrible if I didn't, but in terms of tort and what the law will punish, it's just not part of tort. The only instance when you do have to rescue somebody is if you were the one that put them in harm's way. If the defendant caused plaintiff to be put in harm's way. If the defendant set a trap, the plaintiff falls down some pit, and he's at the bottom of the pit, the defendant has a duty to rescue that plaintiff. So if the plaintiff starves to death because he's at the bottom of a pit, it's the defendant's fault. He had to rescue him. Whereas if I walk by the pit and I see the plaintiff It's not my fault. And here is another topic, and this is on the official outline, that's why I mentioned it here, but it's not that common, is the duty to control the actions of third parties. So obviously you have to control yourself when it comes to being a cautious person, and sometimes you have to affirmatively rescue someone if you were the one who caused the plaintiff to be put in harm's way. But additionally, you might have a duty to control the actions of someone else. The only instance when that really happens is when there's some special relationship or status, when you have some legal duty to protect somebody else. It goes back again to these common carrier innkeepers. Boy, they have a lot on their plate because they have to protect their guests and landlords. And I don't know if there are many landlords who go around protecting their tenants, but nonetheless, it is legally. So an example would be a common carrier innkeeper. They need to, same thing with the landlord, they need to take precautions to prevent criminals from accessing areas where guests or tenants might be staying, and that might include putting up camera, lighting, things of that nature. So you're controlling the actions of third parties by preventing them from coming. And if those third parties do harm your tenants or guests, you are partially responsible, assuming that you're a common carrier, innkeeper, or landlord. Enough about the duty question. It's not the hardest thing in the world. Everybody just has to be cautious, take due care, and that's pretty much it. As long as the victim is foreseeable, you have a duty.